Testing, judge microphone 1. Testing, judge microphone 2. Testing, judge microphone 3. Testing, judge microphone 4. Testing, judge microphone 5. Testing, judge microphone 6. Testing, judge microphone 7. Testing appellant microphone. And testing appellee microphone.
be seated. And good morning. The first matter before the court is State of Maine versus Dustin Foster. This is Kenneth 25-278. I see counsel are present. I'm assuming ready to proceed. Before we begin, I will note that we are being streamed on the web, both by audio and video, and would ask counsel to identify yourselves by saying your names for the record, starting with the appellant.
Morning, Your Honor. Matthew Fortin for the appellant, Dustin Foster.
Good morning, Chief Justice. Darcy Mitchell for the appellee, the State of Maine.
Thank you. And Attorney Fortin, if you're ready to proceed, we'd be happy to hear your argument this morning.
Good morning, Chief Justice Stanfill, Associate Justices, and may it please the Court. The Good Samaritan Statute, Section 1111B of Title 17A, as written and as applied currently in the trial courts, is mostly inaccessible. Defendants are trying to use it, but they're getting resistance at every step along the way. In this case, a loved one worried that her partner had taken some unknown drug called 911 for medical help. She told dispatch that he had relapsed and he was freaking out. He was acting erratically. Dispatch asked if the patient would take any Narcan, and that indicated that dispatch knew it was drug-related. Dispatch asked if the caller knew exactly what he took, and she didn't know exactly. Dispatch asked if she was seeking police or fire or medical help, and she chose very clearly medical, and a Delta ambulance was dispatched to the scene. Stop there for a second. That is why my client should be a protected person under the Good Samaritan law. There was medical professionals were dispatched to the scene of a medical emergency. There was a call for assistance that initiated that, and it was for a drug-related, suspected drug-related overdose. Instead of that happening, a call for help went punished. Sheriffs intervened. They realized that he had a warrant. They called off the ambulance, entered the house, and arrested the man. They carried no medical bags or instruments with them when they went in. This can't be what the legislature intended for this law. This court has an opportunity to clear up the law, potentially in a few ways, so that it's usable. In this case, the defendant filed the motion as required by statute. He met the minimum requirements to trigger a burden shift to the state. Instead, he was required to put on a whole hearing at an unknown burden. By reversing the denial of his immunity, this court could also do at least two things. One, this court could clarify the defendant's burden of production when seeking immunity, and this court can clarify that an overdose isn't only to opiates, but to any drug that may display different types of symptoms. Again, I hope the court takes the opportunity to make the Good Samaritan law more accessible as intended, and with that, I'm happy to answer any questions you may have.
What is the evidence that's appropriate for the trial court to consider in determining the immunity?
It's a little unclear. It doesn't specify.
I'm not sure that we were all that unclear in Bolio. That's what I'm that it's the content of the call that has to reflect. And here there was a lot of testimony, obviously, from the caller. Is that really the kind of evidence that the decision should be based on, or should it be based solely really on the content of the call, maybe the dispatch, what the dispatch was, et cetera?
I think that everything that is within the call should be enough to establish immunity, as well as any other evidence that the defendant puts forward in the motion as exhibits, police reports, that sort of thing. And in this case, it felt like there was more than enough to establish that immunity.
Well, the call started out with her saying that, well, I guess medical, but as the call went on, it was fairly lengthy because
It was.
Didn't it become clear that really she wanted him to get help because she was afraid he was relapsing, and also was really concerned that he was not so much that he was overdosing, but rather out of control, potentially violent, but just out of control?
Out of control, yeah, and that's where the question of what the overdose is to is important. I believe the court interpreted overdose as only to opiates, which you may be familiar is a very depressed, slowed down reaction. Someone sleeping, passed out. In this case, he was exhibiting hyped up sort of behaviors, which wouldn't be a reaction to an opiate overdose, but it could be an overdose to another type of drug like a stimulant.
Well, is it an overdose, though, if he's still alert, regardless of whether it's a stimulant or a depressant? I mean, is it an overdose if he's still just, alert and oriented, et cetera?
That's a great question because the statute doesn't say there has to be an overdose. There has to be a suspected overdose.
Correct.
And so in this case, the caller did suspect something was wrong, maybe an overdose.
And I think that's the key to it. If the call itself is totally innocuous, the call just says, dial 911, yeah, would you send somebody over here to this address? We got a drug situation going on. No reference to overdose. Can the immunity be invoked after the fact by a testimony? The person who made the call said, oh yeah, I was calling back then because I suspected an overdose. Or do we look at the four corners of the call itself?
I think the four corners should be enough, and I think it was.
Did she ever mention overdose during the course of the call?
No, and she doesn't have to.
Wasn't she a nurse?
She was.
So if you're a nurse, wouldn't you, and you see someone that you think is overdosing, wouldn't you say overdose in the call to 911 so they know what to deal with when they get there?
Well, I'll remind the court that the word overdose doesn't have to be said. It's the context of the entire call. In Bollier, that was explicit that the word overdose doesn't have to be said.
But it can't be any kind of medical emergency, right?
No, it has to be related to drugs. It has to be suspected to a drug overdose.
And the 911 dispatcher took it that way, right? She was asking all kinds of questions that would be associated with a drug overdose or a suspected drug overdose. She was asking questions about the person's respiration, skin color. I mean, those are drug overdose symptoms. So, I mean, that's the message that was being received loud and clear by the dispatcher.
I agree. I think the dispatcher did interpret it to be drug-related. And so the argument is that should be enough to establish immunity at the first place and then shift it to the state where the state has to show that it wasn't a drug-related
But in the
overdose.
call, regarding the call to the dispatcher did ask about signs that would be associated with an overdose, but got a negative answer in each instance, right?
I think those are probably signs related to an opiate overdose, but not necessarily a stimulant overdose. This particular defendant had a prior history where his heart had stopped, so if a stimulant could potentially lead to medical issues down the road, she knew that history and she was concerned about him.
So I just want to clarify my earlier question and your answer. So if the call itself is very innocuous, it doesn't reference an overdose, just we got a drug situation going on here, send somebody, and the hearing takes place under the statute, if the person testifies, oh yes, I made that call because I suspected there was a drug overdose, is that enough to carry the burden here?
I thought so. I brought a witness. I brought two witnesses to the hearing, more as in the back of my mind as rebuttal witnesses, thinking the state would have to disprove immunity, and so I had her.
Creates a scenario where it could be abused. I mean, the person could be, they may be fighting with somebody who's on drugs or something like that, and afterwards the police come, he gets charged with a drug offense. They can come back after the fact and wipe the whole thing off the slate by saying, oh yeah, I suspected a drug overdose. And that would be bad faith. It's just one possibility. But do you think the legislature intended to leave that door open?
I think so. It's a very low burden that the defendant should have to show just to get it as it's written in the statute, and it would be the state's burden to show why it doesn't apply, and they should be able to if there clearly wasn't an overdose or there were no drugs related, that might kick it out.
And when you say it's, in your view, the state's burden, contend that means they actually have to put on an affirmative case, or can they meet their burden through challenging the evidence that the defendant puts on?
I think they don't have to. I think Boyer says that they don't have to put on evidence. However they want to disprove, I'm not sure how they would. They would probably call witnesses. I don't know, but
There really weren't any other witnesses to put on, were there?
right. There's the caller, and the state could subpoena them. So I do think that the state should have had to put on the hearing and bring evidence as to why immunity doesn't attach to the defendant.
But I guess following up on Chief Justice Danville's question, it sounds like there really isn't any more evidence that might have been pertinent to this decision here. So why can't we conclude based on this record that the state did meet its burden through cross-examination, et cetera?
The defendant had an unknown burden, so we weren't sure how much we had to show. I thought that having the caller there testifying that she did believe it was an overdose at the time was more than enough. I was able to show that ambulances had been dispatched to the scene, that they were prevented from actually going to the house. So I had what I thought was more than enough evidence to at least meet that first burden, which, again, I'm not sure what the burden was. It's not clear by the statute. It just says a showing, I think.
I believe, based on the briefs, that you and the state may agree that it's a prima facie case. Is that what you're contending?
That is, yes. And so I think there should be some sort of finding after that motion is filed, and maybe the state can respond at that point, but there should be some sort of finding before hearing. And so,
But that's not how we normally do shifting burdens. I mean, you have a hearing, and we have a lot of different contexts where there's shifting burdens, and there's not normally, like, okay, stop, now I'm shifting the burden. I mean, you know, the judge just makes a determination at the end.
That would be fine. But there's a clear shift here to the state, and so when does that happen? Again, the defendant made what I thought was enough showing to just establish immunity, and then it should have shifted. So that's, I would think, before hearing would make sense for that shift to happen.
Thank you.
Thank you.
And Attorney Mitchell.
May it please the court. On February 7th, 2025, Annalyn Green called 911. She told the 911 operator that she thought her boyfriend, Dustin Foster, had relapsed. She reported that he was freaking out and screaming. Green said she had left the residence to call 911 because Foster would not stop yelling. He had also threatened to burn the house down. When Green went back into the residence, she could be heard arguing with Foster. She told him to stop breaking stuff and later testified that at that point, Foster was breaking his phone. At no point during the 911 call did Green say that she thought Foster was experiencing a drug-related overdose. In addition, there was no indication that Foster was experiencing a medical emergency. Throughout both the 911 call and her testimony at hearing, Green acknowledged that Foster was alert and that he was breathing normally. She acknowledged that at no point did he ever lose consciousness. Green is a nurse with 13 years of experience. She is trained in providing CPR and has performed CPR on numerous occasions in her professional life. At no point during that day did Green administer any kind of life-saving care to Foster. She also did not attempt to administer Narcan, despite believing that she might have had some in her vehicle. No one else administered any medical care to Foster that day either. An ambulance was staged near the residence when Green called 911. However, the police canceled the ambulance, so no medical personnel ever met with or treated Mr. Foster. Deputy Reynolds did not testify at the hearing, but in his report, he said that Foster denied using drugs and refused medical assistance. In order for the immunity statute to apply, there must be 1, a call for assistance for a suspected drug-related overdose, and 2, medical or law enforcement personnel must be dispatched to the location of a medical emergency. This court's decision in Beaulieu makes it clear that it is the content of the call that must reflect the caller's suspicion that an overdose has occurred. In this case, the motion court correctly found that the 911 call did not reflect a subjective belief that Foster was experiencing an overdose. In addition, as in Beaulieu, the motion court did not make a finding here that there was a medical emergency. There would have been no evidence on the record to support such a finding, as no medical assistance was required or rendered by anyone on scene. On these facts, the motion court correctly determined that Foster did not sustain his initial burden and that the immunity statute did not apply. I would be happy to take any questions the court has.
What standard of review do we apply to the trial court's determination there was no immunity here?
Your Honor, I think that's an interesting question that hasn't been resolved by Beaulieu. If the court decides that the initial showing from the defendant is a prima facie showing, then in that case, the standard of review, according to Cookson, is that the lower court's finding that a defendant failed to present a prima facie case will stand unless the evidence compelled the court to find to the contrary.
So it's clear error, basically.
Yes, Your Honor.
Well, let me ask about that. I want to clarify terms, because in your brief, you do refer to a prima facie case. It seems to me that the way the statute is written, the burden on the movant is to meet a burden of production, not to present evidence that would result in findings initially. Do you disagree with that? The language of the statute is that the defendant needs to present evidence to establish immunity. And that strikes me as not having any burdens of persuasion, not calling on the court to weigh evidence, but instead just to meet a burden of production. And if the burden of production is met, then the burden shifts to the state to disprove immunity by clear and convincing evidence. So really, in the criminal context, it would be similar to the burden that a defendant has to generate a justification, self-defense or whatever. In the civil world, it would be, presenting evidence to defeat a summary judgment motion, just to meet the burden of production, to present some evidence, which, if believed, would carry the day. So do you agree with that approach?
Well, I think Your Honor is entirely correct in your reading of the statute, right? So 17A MRS 1111B4 indicates that the criminal defendant has to move the court before trial, or may move the court before trial, to determine whether the defendant is immune from prosecution. It says once the defendant has filed a motion and has presented evidence to establish immunity.
Right, evidence to establish immunity, not to actually establish the immunity, but to present evidence, burden of production.
Correct, but Your Honor, the state reads that as indicating that the defendant has the initial burden to provide enough evidence to the court that would allow the court to actually make a finding of immunity, unless the state were then to provide evidence that would contradict
Correct.
it.
And your word use of the phrase "to allow" is really critical, because the defendant, in my view, and tell me where you disagree, the defendant, in my view, does not have to persuade the judge of anything to have the burden shifted over to the state.
I think I would disagree. I think that it says that the defendant has to provide enough evidence to establish immunity. And then again, if that has happened, then the burden shifts to the state to show by clear and convincing evidence that the immunity statute does not apply to this particular defendant.
Is it your view that the burden shifted here and that it was your burden to disprove? Or is it your position that the defendant failed to present evidence to establish immunity?
It appears to me that the trial court never shifted the burden to the state. And I also don't think, and the state maintains, that the defendant failed to present enough evidence to allow the court to make the necessary findings that would have triggered the burden shifting.
Was it sufficient, during the hearing, as you know, there was a penultimate question. When you made the call to 911, were you worried that Mr. Foster was experiencing an overdose? Answer, yes. Is that enough to satisfy that burden of production or prima facie?
No, Your Honor, I don't believe that it is. I agree that that is what Ms. Green testified to at the hearing. Her testimony at the hearing seems to be in contradiction to the content of the call itself. As this court indicated in Beaulieu, it's the content of the call that controls. And I think Your Honor had asked a question previous about whether or not we should be confined to the four corners of the call. I think that's a good way to put it. I think the state could have reasonably chosen to object to Ms. Green's testimony at the hearing. It chose not to do that. But I think the fact that her testimony at the hearing that this was an overdose is fairly directly contradicted by the nature of the call. And
So is the judge making credibility decisions at this juncture of the hearing, or is this just, isn't this just a circumstance where the defendant has to kick the door open, and then credibility findings would come in later when the judge makes the actual decision?
I think that that is true, but I don't think that what the court did here was actually make a credibility finding. I think that the motion court was confronted with conflicting evidence presented by the defense in his attempt to meet his initial threshold burden. And I think that when the motion court is confronted with conflicting evidence, that court is allowed to consider whether or not that evidence put together is sufficient to show that the defendant has met his threshold burden.
Do you think that based on the four corners of the call, that a medical emergency there was evidence to find or to present, there was evidence presented of a medical emergency?
No, Your Honor, I don't. I think when we look at the four corners of the call, Ms. Green was very clear, and the 911 operator did a wonderful job about asking a lot of questions to try to determine whether or not there might be a drug overdose occurring. She asked if Mr. Foster had ever lost consciousness. She asked if Mr. Foster was changing color. She asked if he was breathing normally. So she asked all the correct questions, and the answer from Ms. Green to every single one of those questions indicated that there was no medical emergency and that there was no drug-related overdose occurring.
But what if it was an overdose of a stimulant? And was it in the call itself where there was a mention that the defendant had a heart condition or some other susceptibility to using that substance?
I don't recall whether or not there was an indication within the content of the call that he had a prior heart condition. I know that testimony came up at hearing. Ms. Green certainly indicated during the content of the call that she suspected that Mr. Foster may have relapsed. I don't believe what substance she indicated he took. It's clear from Deputy Reynolds' report that he believed that the substance that was later recovered was actually fentanyl.
Counsel, I know we've said very recently it's the content of the call that controls. What would we, I know it's not this case, but what would we do in a situation where the content of the call is minimal? For whatever reason, someone calls, says, my friend needs help, come quickly, and hangs up. The police get there, and it does, in fact, turn out that the friend is overdosing. Don't we need more context beyond just, those few words on the call to determine whether it was for a suspected overdose or not? How would we handle that situation?
Putting Beaulieu aside, as if that precedent, I mean, obviously right now the existing precedent is that no, it's the content of the call that controls. If we were to put Beaulieu aside, then certainly I could understand that potential argument in the event that a call was very ambiguous or unclear. But in fact, we are guided by Beaulieu. This court was very clear in Beaulieu that it's the content of the call that controls. And on the facts of this particular case, the caller in the call not only didn't mention an overdose, but also mentioned repeatedly a lack of any medical symptoms that might potentially indicate a drug-related overdose. And she was also very clear that in addition to that, Mr. Foster's behavior was concerning, right? He was yelling, he was breaking things, he was threatening to burn the house down.
If it's only the call that matters, then why is there a burden shift to the state to provide some clear and convincing evidence? Wouldn't that be other than the call?
And that's a good question, Your Honor. But I think that we're also dealing with a situation where there are multiple things there are multiple components of the statute that have to be met, right? So it has to be in response to a call for assistance for a suspected drug-related overdose, but then there also has to be a medical emergency.
Well, there was an ambulance that was dispatched in this circumstance. It's just that the police went in first, correct?
That's correct. The ambulance was dispatched, staged near the residence, and then never sent in. right? So medical personnel never met with Mr. Foster, they never evaluated him, they never treated him, they never provided any kind of medical care to him whatsoever. According to Deputy Reynolds' report, when he went into the residence, Mr. Foster denied using drugs and himself refused medical assistance. Deputy Reynolds would have obviously had the ability to ask the medical personnel to come into the residence and provide treatment, and clearly didn't feel as though that was necessary.
So it sounds like what you're saying is that essentially, under the statute, the defendant probably meets their burden if the call for assistance, if there's information that the call is for assistance for a suspected drug-related overdose, but there are other elements to it, and so when you start talking about the prosecution's burden to show by clear and convincing, it may not be on that element, it may be on one of the other elements that the prosecution might prevail. In this case, though, I think the judge was focused on that first element about whether they were dispatched to the location of a medical emergency in response to a call for assistance for a suspected drug-related overdose.
Yes, I agree with that entirely, Your Honor.
Okay.
So in your estimation, the only relevant evidence, because the court didn't get past this, that the court should have looked at was the content of the call itself?
No, I don't think that's true, because again, there's that second sort of prong or element about whether or not there's a medical emergency that's occurring on scene.
Right, but he really didn't focus on that, right, the court? Or are you saying that was a part of his ruling?
I think that the hearing focused on that. I don't believe that the motion court made an explicit finding about whether or not a medical emergency was occurring. However, in Beaulieu, this court also considered the motion court, in that case, its lack of a finding of a medical emergency significant as well. And I think that's exactly what we have here.
What are we to make of the police report that was put in as Defendant's Exhibit 1, which says that the caller called stating that the defendant was being violent and took fentanyl, that's the reason for the call?
I mean, I think that that's consistent with the content, not the fentanyl, but I think the fact the defendant is being violent was consistent with the content of the call. The content of the call talks about how he's threatened to burn the house down, he's breaking things. They can be heard arguing with each other at the end of the 911 call once she's gone back into the house. And again, she felt comfortable enough in his safety at that moment to actually leave the house entirely as a nurse and leave him unattended within the house while she stepped out to call 911.
So see subsection 4 as being an opportunity for the state to rebut a call that would be prima facie. Let's say the call does say he's having an overdose. So at that point, they've met that burden of production, that burden to, but that subsection 4 would allow the state to put on evidence to say, yeah, they said that, but that's not what was happening. Matter of fact, they all conspired there and said, let's just say it's an overdose, and that way we're going to be home free. It really is a bailout provision for the state to avoid the presumption contained in the telephone call.
Absolutely, Your Honor. Thank you.
Thank you. 3 seconds left. How about that? Attorney Forden?
Thank you. A couple things to address. The first, if it is the content of the call that we're looking at, what's happening is testimony and evidence from the hearing is being taken into consideration here, and when it shouldn't be. So,
I mean, didn't the judge really say he doesn't find persuasive the testimony, and he did focus on the call, didn't he?
I think so, but in argument, the nurse's background was factored in when it really shouldn't have been, right?
Yeah. Let me ask you this: that you put in the police report, and the police report starts off. I mean, the police report. I know it's written after the fact, but it doesn't seem to. It seems that the policeman's communication from dispatch was not of a medical emergency or suspected drug overdose.
I think the dispatcher.
And we didn't hear from the dispatcher directly.
Right. I think
so, isn't it fair, though, for the judge to listen to the whole call and say it may have, even if it started out as a call, potentially as a call for medical assistance for a suspected drug overdose, as the call developed and the dispatcher asked all the questions and got negative answers, but also, there was, the caller herself was really focused on stop breaking stuff, things like that to him, and that he was out of control. Weren't they entitled by the end of the call to understand, and the judge also, this was not a call for a suspected drug overdose emergency?
I think so, but there's a call for assistance to start with, and then law enforcement or medical were dispatched. So the state just laid out that those both need to happen, and they both happened here.
Well, it's not just a call for assistance, though. It's a call, it's more than that, right? It has to be a call for assistance for a suspected drug-related overdose. Let me ask you a different way. Clearly, you don't have to say, I suspect an overdose. We understand that. And it's not limited to a specific kind of drug either. But doesn't there have to be something about the call that makes the dispatch or the responders think that it is, in fact, a drug-related emergency, not just that somebody is using drugs and acting out? I mean, those are different things.
I think so, and I heard the worry in her voice. I heard her call was out of concern for his health, and that's what prompted her to call in the first place. She doesn't say the magic words, but she doesn't have to either. There were other elements thrown in too by dispatch, I think. I heard the dispatcher tell someone else he's extremely violent, and that was said early on in the call.
But wasn't that an appropriate comment given what was going on in the background?
I don't think at that point there was. It was added in. May I finish?
Yes, you may.
I think it was added in, and as was a concern about a possible knife when it was maybe a needle instead. So there was extra thrown in by the dispatch.
Thank you.
Thank you.
Thank you, counsel. Thank you for your argument here this morning. As is our usual practice, we will take the matter under advisement, issue a written decision in due course. And Attorney Forden, I understand this is your first time appearing in front of this court. Our custom is to invite counsel back to chambers and take the greetings of the court.
All rise.
Please be seated. Good morning. Welcome. The next matter on our docket is York 25-347, Richard Lytle et al. Versus Douglas Lind et al. Record reflects counsel are present and prepared to proceed. We will be streaming our arguments today live on the internet, audio and video. And for that purpose, I'm going to ask counsel to stand in place, give us your name and the party you are representing. First for the appellant.
Good morning. Tyler Smith for Richard Lytle, Sandra Lytle, and Greg Wilson.
And for the appellee.
Gordon Smith for the appellees Douglas and Louise Lind.
Thank you. I'll just note this may be the first case I've seen where both counsel have the same surname, so I'm struggling with how to differentiate how I designate you. But I think in this case, there's no question about it. We're going to hear first from the appellant, Mr. Smith.
Good morning, and may it please the court. This case presents a narrow legal question. Does Maine law allow a servient estate holder to permanently occupy part of an express right-of-way so long as the dominant estate holder is still able to squeeze by the impediment? And this court has consistently answered that question no. The passability is not the test. In Rhoades, this court held that when expressly granted, a dominant estate holder is allowed to use the entire width of a right-of-way. That case involved a 50-foot right-of-way, of which 30 feet was already being used as an existing road, and they wanted to expand it by 10 feet. In Mill Pond, this court reaffirmed that holding, and it explained that an obstruction is only permissible if it doesn't interfere with the actual use by the dominant estate holder. In that case, the sign that was at issue was in a location that was not actually being used for ingress or egress, and therefore that was the result in that case. And then finally, in Kinderhouse, this court recently rejected the idea that an obstruction is lawful merely because you're able to navigate around it. Similar to Rhoades, that case involved an area that was already passable, and the dominant estate holder wanted to use the entire width, or an additional part of the entire width of the right-of-way. So applying these principles, in this case, the fence that was erected in the right-of-way is an unlawful impediment, and the trial court should have granted summary judgment to the appellants. But even if this court disagrees, and this court accepts the arguments being offered by the appellees in terms of the analysis, the correct result is not to affirm, but it's to remand for fact-finding as to the reasonableness of the fence, which would be consistent with many of the cases on which the appellees are relying in this case. And with that, I would open to any questions.
Thank you. This is one of those cases where both parties cite the same cases for different propositions. So our task here today is to parse through that and determine where the appropriate result takes us. In this case, it's my understanding that the facts are pretty clearly set out. You made a passing reference to remanding for findings of fact, but the record here has extensive affidavit and photographic renditions that are very helpful. I think we have a pretty good picture from the photos as to how the lay of the land sets out there and what the issues are there. So I'll just ask you at the outset here, I'll adopt some of the reasoning offered up by the appellee. Looking at the pictures, I see a fairly wide passageway, the right-of-way, it's 10 feet wide, and there is a rail fence going right down the middle, but no one, even a medium-sized party, could easily traverse one side or the other. And I believe your position is that that's of no import, that the fact that the fence is there, we have the entire width, every inch of that width, and the fact that people can't walk down the fence unless they're doing some tightrope operations. So that constitutes an impermissible impediment. Have I misstated your position?
No, Your Honor. Our primary position is that the fence is an impermissible impediment because it obstructs really the most natural location for somebody to use the right-of-way.
But it doesn't, this is an easement, a right-of-way for pedestrian traffic. No one's really prevented from using or obstructed from using, unless for some reason they wanted to tiptoe down that very narrow area. They still can use the easement without any restrictions.
That's correct, Your Honor, but again, this court's precedents explain that passability is not the test because the same could be said about Rhoades and the same could be said about Kinderhouse.
But it is actual use, and it is actually being used by pedestrians, so why doesn't, even under your, through your lens of actual use, why doesn't this satisfy that test?
Well, it does satisfy the fence is interfering with the actual use.
Well, no, my point is the easement's being actually used, and is there evidence in the record that it's been impeding actual use?
Well, the fence doesn't categorically prevent use, but again, that's not what any of this court...
Well, it does categorically prevent use of the square footage where the fence is located.
Well,
and our Kinderhouse stands for the proposition that you get to use every square inch. So when you have a permanent obstacle, it is preventing the use of the area on which it is placed. But let me ask you the dreaded hypothetical. We have said that a fence at the beginning, if you can open and close it, it is okay. So if this fence could be open and closed, would that be okay?
Well, first, let me say...
It's not this case.
No, understood, and Your Honor did put it more accurately than I did regarding the square footage of the fence. That's indeed correct. With regard to the what happened in the Flaherty case with the fence that could be opened and removed, that area where the fence was, or excuse me, where the gate was, could still be actually used, and that's really the difference. It could still be used. People who come up to the gate could open it and close it, and that case also did have some added complications in that you were dealing with a settlement agreement, if I remember correctly, in that case, with multiple instances of going to court, whereas this is really just a straightforward issue of intent of the grantor, and in this case, the grantor intended that there be a 10-foot wide right-of-way allowing pedestrians to access the beach area.
Can
I
you
think
help, and maybe you've just done it, you're talking about Flaherty where the gates, I gather, at the end of the right-of-way, or the beginning of the right-of-way, is that right?
That's right. It's at the beginning of the right-of-way, and it could be opened and closed for people traveling through.
We talk about, in that case, we have this language of the owner of the servient estate may not materially impair, unreasonably interfere with the use of the right-of-way. We have other cases like Kinderhouse saying, you have the right to use the full extent of the described land. You can't have any impediment. You can't restrict a particular point. So how do we read those? Are those cases in tension, or how would you suggest we read them together?
No, I think those cases do fit together, Your Honor. And one distinction with Kinderhouse, too, is when you look at the facts of the case, and that case was, of course, decided, I believe, after some evidence, the gate in that case was actually open the entire time, if I remember correctly, of the...
Kinderhouse is the tree, so...
Oh, excuse me. I meant to say Flaherty, not Kinderhouse. I meant to refer to Flaherty. So in Flaherty, the gate was actually open. So as I read Flaherty, there was no argument that the gate was, in fact, impeding access beyond the mere fact that somebody would have to stop momentarily, open up the gate, and walk through, had it been theoretically closed.
The appellee argues that we have not and should not create a rule of law that is a wooden rule. It is inflexible, that every inch is permissible to use. I assume you obviously disagree with that. But isn't there some tension in, if you pull out snippets of, I'm not going to say dicta, but text from some of our cases, it does add some support to their position, saying that if it's not an impediment, it's something the court should consider. Should we adopt a wooden rule that says inch to inch, or something? I was about to say in the middle. That probably was the wrong choice of words. but something less than a absolute rule saying every inch from one side to the other.
Well, I'm not asking the court to adopt a rule. I'm asking the court to apply the rule that's been in place ever since Rhoades, which is that the dominant estate holder does have the right and the prerogative to use the entire width. I think the issue that is implicated by Your Honor's question really gets to the situation of the actual use of the right-of-way by the dominant estate holder, and that's how you can distinguish cases like Mill Pond Condo Association, where there was a small sign placed in the far corner of the right-of-way, which was not being used, which in fact could not have been used for ingress or egress, whereas in Rhoades, there was already an existing road that was perfectly capable for ingress and egress. Same thing with Kinderhouse. In Kinderhouse, there was an existing road that was perfectly capable for ingress and egress, and in both of those cases, the dominant estate holder decided, as consistent with the intent of the grantor, that they wanted to use an additional piece of that property for ingress and egress.
If it's an obstacle like a tree, that was what we said in Kinderhouse, and to some extent a fence is a split. There's the lumber. It's a lot like a tree. But if there's something that's temporary, that somebody put a pail and left it in the easement, and you can move it, then that's not a problem, is it?
I would say as a one-off situation, probably not. But if you get into a case where a servient estate holder is habitually leaving things in a right-of-way, certainly that's a situation where somebody could bring suit and claim that there is an interference with the right-of-way.
Like vehicles?
Could be vehicles.
Well, there are vehicles here.
That's correct, Your Honor. I agree that there are vehicles in here, but still, that is not, the fact that another party may be engaged in activities that interfere with the use of the right-of-way does not itself justify the fence.
Well, if this were a fence on wheels, so all you'd have to do is move it over to the side, dreaded hypothetical, would that be a problem?
I think if this was a fence on wheels, we would probably be in the same situation that you have in Flaherty, or we'd be closer to that situation, because then the impediment would be, in theory, easy to move for pedestrians who are traveling through. So I think in that case, we would probably be controlled by Flaherty.
So, Mr. Smith, I didn't see anything in the record, and correct me if I'm wrong, about the reasons why the Lynns put the fence up. First of all, am I correct about that?
There's no direct evidence of it. However, I think if this case went back to a fact finder, somebody could look at the facts and see that the fence, which originally included a final section that blocked access to the river from the Lynn property, could reasonably infer that the purpose of the fence was to ensure that nobody used the 5 feet on the Lynn side.
So is that motivation relevant? I mean, if this is sort of like a spite fence in sort of a loose terminology, would that make a difference as opposed to it having some real important function?
Under our analysis, that last section was removed. Under our analysis, I don't believe that's relevant. However, if you do accept the so-called case-by-case determination analysis that the appellees are proffering, in that case, I think that's perfectly reasonable and something the fact finder would need to consider, which is actually consistent, again, with Flaherty, because in Flaherty, part of the discussion that the court had was what was the purpose of the gate.
And just a real quick question as your time is running out. Did you ask in response to your response to the Lynn's motion for summary judgment, did you ask for there to be an evidentiary hearing, a trial on the facts, if your motion were to be denied?
Well, I don't know if we made we opposed their analysis, so I think implicitly yes, but not an express request for fact-finding.
All right, thank you. All right, the other Attorney Smith on behalf of the appellees.
Thank you very much. Good morning. May it please the court. To respond to a couple of points that were made regarding Rhoades. In Rhoades, you have to look at the language of the grant that was made. And the grant in Rhoades was not for a right-of-way. It was for a quote-unquote road. And the court made a point of that, stating that there was the grant was for a 50-foot wide road. and it wasn't merely for a right to repass and pass. And that 50-foot wide road was actually located and maintained and marked on the ground. So that language from Rhoades has been brought forward and sort of expanded to mean to where the court has made a broad statement that the easement holders, entitled to every aspect of the easement, but the facts of Rhoades and the grant in that easement don't really support that broad conclusion. And I would say with Kinderhouse, I think Kinderhouse has to be read in connection with Beckerman v. Conant. They were argued almost a year apart, but they were issued less than a week apart. The decisions were issued less than a week apart. And Justice Mead, your point is absolutely well taken, that in Beckerman, the court said both the easement holder, where an easement is specifically described, the easement holder has a right to use every aspect, every inch of the easement, regardless of necessity or convenience. And in that same paragraph said, the servient said that the servient estate holders have the right to use their land in any manner as long as the use does not materially impair or unreasonably interfere with the dominant estate holder's use of the easement for its intended purpose. Justice Yelm, to answer your question about the purpose of the fence or the Lynn's purpose in erecting it, it is not in the record, but the reason that they did that was because the use of the abutting property owner, that abutting property owner rents out his residence, and the tenants were sort of using the Lynn side of the easement as a staging area. They would park on one side, and then it would sort of overflow, and there would be gear and other items that were stored, in fact, blocking the easement. And so the Lynns put up that fence to prevent that from happening. And I would say that the 5-foot width, and I think the court sort of hinted at this, where you have 5 feet on either side, that's consistent with pedestrian access. We've all seen beach access where it's a path of sand that goes down and you can walk down there, and that's, the purpose of this easement is undisputed. The appellants agree that the purpose is for pedestrian access to the water with, water-related equipment.
On. Oh, it's a 10-foot easement. Let's say the fence was 1 foot wide. Haven't you taken 1 foot and now it's a 9-foot easement?
I would say there would be 2 4.5-foot wide easements.
You have taken away a part of the easement.
That's right. That's right. And I think that the court.
How can you do that?
Because the court has looked at the facts of each specific case where this claim has been made of impairment of an easement.
But you could drive around the trees in Kinderhouse.
That's right. And Kinderhouse, I would argue, is sort of at the far end of the spectrum where.
Wasn't the difference in Beckerman, it's movable? We're not talking about a permanent obstacle that is effectively taking away a dimension of the easement?
Well, in Beckerman, as in in all the cases where the court found that the easement had been impaired, the use of the easement had been impaired, there were specific allegations of fact supporting that the easement holder was not able to use the easement for its purpose. In Beckerman,
What if I had a little trailer to bring my kayaks down to the water, and the trailer was 6 feet wide? Where's that going to fit within the easement as it's been obstructed here?
Well, we're talking in hypotheticals. As a matter of fact, there's more than 5 feet on either side of the easement, where although you would be going outside of the easement
on somebody's property.
Theoretically, but people do that that's already happening.
I think the math
every single time people walking down, they're not abiding by a 5-foot stretch. They're just walking back and forth.
Without authority. They're trespassing.
Is there a tension in our easement jurisprudence? I mean, we have said, Kinderhouse has pretty blunt language in there. You get to use the whole thing, anything the way, but we've also said, but the serving estate has some right to use the property in the easement. Is there a tension there? Is that what you're...
I think there are. I think that there is a tension. The Kinderhouse included this little safety valve in footnote 8, where it said, well, if the the impediment isn't, impairing the easement, then it might be okay to have an obstacle.
But maybe that is just sort of blessing Mill Pond, saying, if you own the place, you still can put a sign as long as it doesn't. To reconcile it, we have not, I believe, created a wooden rule, but maybe it's more like a fiberglass rule. Still
Well,
modifiable, but
I think
we haven't totally cut off the right of the serving estate to use the property.
the court has issued language both very strongly in favor of the easement holder rights and very strongly in favor of the servient estate, the fee owner's rights. And the court has been able to sort of weave between those by looking at the facts of the specific case and whether there was any obstruction, any meaningful impairment of the use of the easement. And in this case, there is no material fact of any specific instance where the appellants have been prevented from using the easement.
Count one is a declaratory judgment count, so that's sort of an abstract determination of people's rights. It doesn't rest on specific facts.
You need to have.
So there doesn't need to be evidence of any, particular inability, that the Lytles ran into, any problems that they ran into, to form the basis for their claim, at least for the declaratory judgment part of it.
I would disagree with that. I think there does need to be some specific fact, and in fact, the facts in this case are akin to Flaherty v. Muther, because in that case, the court held that the concerns of the easement holders were speculative. They hadn't put forth that was the same set of facts
Is it
here.
declaratory judgment to get a ruling from the court, a declaration of rights and responsibilities?
Yes.
So you don't need to have some actionable conduct or some, bad encounters.
Well, I would,
neighbors, to form the basis for there to be a declaration of rights.
I mean, I would analogize this as well to the law court's oral argument in Masucci versus Judy's Moody, where the court was seriously questioning the plaintiff's standing because there was not a single instance in the record where they're shown they had actually been prevented from using the intertidal land.
Let's go back to Justice Yelm's kayak hypothetical. I mean, I think you've acknowledged that in that circumstance, someone has a 6-foot wide kayak trailer, that they can't use the right-of-way with the fence in the middle. They would be encroaching on neighboring property, correct?
And maybe the answer there is that 6-foot wide trailers are not part of a pedestrian easement.
Well, that's the question, right? This is a pedestrian access to the water.
Correct.
Doesn't that imply that you can take, various types of boating equipment, et cetera? Isn't that part of use of the water under sort of normal understanding?
It does, and the facts that have been stipulated to in this matter refer to the easement as a pedestrian easement with hand-carried watercraft,
All right,
not
so
trailered
what if you have
watercraft.
a kayak that's 10 feet wide, you've got 2 people carrying it, and it's really awkward to carry it front to back, you want to carry it horizontally. You can't do that with the fence in place, right?
No, but you could just turn it 90 degrees. I mean,
Well, but maybe it's difficult to carry it that way.
That's right, but if to the extent that that's happening, that is outside of the scope of the easement, which talks about pedestrian access with hand-carried watercraft.
Well, that goes to the question of whether this should be decided on summary judgment or not. I mean, if there are reasonable ways to use this easement consistent with the servient estate holders' rights, shouldn't that be more fleshed out more on a fuller record than what we have here?
I don't think so. The parties submitted this to the Superior Court on summary judgment.
Just under the rule of physics, if Kinderhouse stands for the proposition that you can use every square inch, and this is a permanent obstacle, you don't need much more fact-finding to understand you can't use the square inches where the permanent obstacle is, right?
That's correct, but I don't think that has been the law court's
So what's
test.
the difference in the facts? There was a big tree in Kinderhouse, and you could get around the tree, and there was a finding that you could get around the tree for the purposes, and we said No, because you have the right, because when you are putting up a permanent obstacle, you are then shrinking the easement.
So, Justice Connors, you are arguing for that per se rule of any obstacle is a per se
Permanent
violation of the
obstacle.
easement. And that is not what the law court has applied. So that would be adopting a new rule.
That's not Kinderhouse?
Kinderhouse, well, Kinderhouse also included that language pointing to Mill Pond where it said, but you know what, if that obstacle doesn't impair the use of the easement, maybe it's okay.
It was in a location that, quote, cannot reasonably use for the purpose of ingress and egress. Not that it was you couldn't use it for the purpose. Not that you could get around it. It was, that's an area where you just can't use it. It's like dead for the purpose of the easement. That's not this situation.
That's true. I agree. I mean, it is a permanent, obstacle in the easement, but the court, even when it went to the extent it did in Kinderhouse, also included the caveat that not every obstacle, permanent or otherwise, violates the easement.
Did it say permanent or otherwise?
I don't think it said permanent or otherwise.
It
I'm saying
cited Mill
permanent or
Pond.
otherwise.
But it did say reasonable.
Yeah, Mill Pond was a permanent obstruction.
But it
That
did
was
say, it did say reasonable.
reasonable use of the
Yes,
easement.
and that's my question. Can we determine reasonableness on this record?
Yes, I think that the court can.
Is that a finding of fact or a conclusion of law? I mean, the finding of fact is that there's a fence going down here, and the issue of law, which we reviewed de novo, is whether or not that constitutes an obstruction. And following up on Justice Connor's question, I mean, she would say that the users of the right-of-way, the dominant estate, would have the right to walk down the middle if they want to, and they can't. I didn't mean to take the words out of your mouth, but I heard you think it.
There you go.
That's correct. Reasonableness is a determination of law, but it needs to be made based on a finding of fact that there's some impairment. On this record, there's no impairment.
You are taking an easement and you are shrinking its dimensions, which is what you're doing if you have a permanent obstacle, aren't you?
Right, and I don't think that, so the case of Roch and Kinderhouse are still, first of all, Roch is not applicable because that was talking about a 50-foot wide road.
Kinderhouse is the recent one.
Yes.
And the distinguishing feature between Kinderhouse and this is what?
Let me just say, I think Kinderhouse went too far. I think that that's an
You're
outlier.
still stuck with Kinderhouse, and you still have the problem that this is for pedestrian use. And to the extent that people who are walking through the area can carry objects to go down to the water, they may have to carry something that is 7 feet wide, very heavy. They're not able to lift it over the fence, and that's an impediment to the utilization of the right-of-way, is it not?
I would say to the extent that those types of items are trying to be brought down the easement, they exceed the scope of the easement, which is a pedestrian easement for hand-carried craft.
One more hypothetical. One of the other parties puts in a brick fireplace for grilling out there, and it's 4 feet wide. It goes right out in there. People can obviously walk out and around it. Is that permissible under your theory?
I would say no, because there you have the reasonableness question.
Okay.
And the reasonableness question is, no, 1 foot is not reasonable.
Okay,
And
but the fence is reasonable.
yes, because 2 5-foot right-of-ways that allow direct access to the water for pedestrians.
How about
That-
2 4-feet, because your fence is 1.5 feet?
That's
that
not,
reasonable?
those are not the facts in front of us. That may or may not be reasonable.
So this is a nice fence and it's small, so that makes it reasonable as a matter of law?
I think it's reasonable because we have evidence of people using the easement for its intended purpose without obstruction. Now, the reasonableness question also
What do you
has
mean
to,
by without obstruction?
because they're walking in a straight line to accomplish the purpose of the easement.
But not every straight line
Right.
within the easement.
There's no right to zigzag back and forth across the easement. That's that's an access easement to get to the
Right-of-way,
water.
They can't walk. If they wanted to zigzag, you're saying that that's an overburden?
The purpose of the easement is to access the water. So if they want to play a game, yes, I do think that there is no right. The easement holders don't have a right to walk back and forth.
There's evidence at the end of the Blomberg part of the, Blomgren
Blomgren.
part of the right-of-way floods sometimes. So if I'm walking down their part of the right-of-way, and I see that there's too much water, that means, because of the fence, I've got to go back, right, to the top of the fence and circle around and go back down on the Lynn side.
Which is not an unreasonable use of the easement.
Justice Lopez, did you have a question you want to talk?
No, I'm fine, thank you.
Thank you, Mr.
Thank you very much.
All right, and Attorney Smith, one, we'd be happy to reserve 2 minutes for rebuttal. Happy to hear you in rebuttal.
Thank you. And building on the boating example, whether it's a rowboat or maybe a canoe with an outrigger or some other reason why the dominant estate holder might need to use more than a 5-foot section, the intent of the grantor is really what controls here, and the intent of the grantor was that the dominant estate holders would have a 10-foot wide right-of-way, and what the fence does in this case is essentially slice that in half and say, no, no, you are allowed to have 2 5-foot right-of-ways, and if you require the full use, you're not going to be able to use it.
So what kind of things can the Servian estate do within the easement?
Well, one thing that they can't do is erect a permanent obstruction.
Understood your position. What can they do?
Right. So I think if they needed to put something in the easement area temporarily, I think that's where you get in.
Like a car?
I think it depends on the frequency of it. I mean, if the person is parking a car regularly, then we get into the same issue that the court actually adjudicated below regarding what's in the practices on the Blomgren side of it, where there would frequently be cars, and that is, in fact, an
They move
obstruction.
the little movable grill into that area and have a party. That's okay?
I think if, again, I think if it's a one-off situation, that probably doesn't rise to the level of an unreasonable interference. But when you deal with something that's permanent, that changes the dynamic because it's an immovable structure that is going to essentially forever restrict the scope and the size and the usefulness of the easement.
I'm just going to throw something else out at the end of this here. Obviously, you've looked at other jurisdictions, different rules in different places. And some jurisdictions have adopted a philosophy that if the Servian estate has a valid purpose for putting an obstruction in the way, they can do it. I'm not saying we should or shouldn't accept that, but if it is important to the owner of the Servian estate to create a physical demarcation of their property line because of an extraneous purpose, is that something that we should, and apparently that's what happened here, that's extrajudicial, it's not before us here, but is that something that we should fold into our jurisprudence, that a valid purpose for an obstruction would be a permissible use by the Servian estate?
I don't believe so, Your Honor. That's certainly not an issue that's been developed. And had it been an issue, that's something that would have required fact-finding, but of course that's not the situation here.
All right, thank you. We appreciate the briefs and arguments of counsel. We'll issue a decision in due course. And with that, court will be in recess.
All rise.
And good morning, you can be seated. The matter before the court is Penobscot 2524, State of Maine versus Kenneth Rhoades. I see counsel are present. We are being streamed on the web, both by audio and by video. Before we begin the argument, I was asked if counsel would identify themselves by saying their names for the record together with the party you represent.
Good morning. I'm Jim Hawanik. I represent the appellant.
Good morning, Your Honor. May it please the court. I am Christopher Smith. I represent the State of Maine appellee.
Thank you. And Attorney Hawanik, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, Chief Justice Stanfield, members of the law court. Good morning. May it please the court. My name is Jim Hawanik, and I represent the appellant, Kenneth Rhoades. As you may know if you've read some of my recent briefs to this court, having done this for 40 years, and I always hate when I say that, one of my concerns as a criminal defense lawyer has been that the trials just don't seem to be fair anymore. I don't know how else to say it. I feel like there's been a diminishment of the hearsay rule over the years that has benefited the state, and other rules. And I've done over 160 jury trials, and that's just my observation. I don't speak for the defense bar, although I would assert that I think a lot of them do agree with that. And this case, to me, personifies what's going on. This has sort of a smorgasbord of issues that I think represent some of the changes in the rules of evidence and the way courts are analyzing evidence that has led to this problem. We have a case where maybe a 5-minute suppression hearing, maybe 10, judging from the transcript, in which a police officer came in and said, I looked up and I saw he was speeding. And that was it. No other objective corroborating evidence. We have the issue of the surrogate chemist coming in and testifying to another chemist's work. This is an issue that this court is familiar with. It's a case that I argued, State versus Thomas. And of course, we have the obligatory sanctions, discovery sanctions, that seems to be arising every other case that we're doing. So I think it's an important case. I think Attorney Zachary Smith at the trial level did a good job of preserving some important issues. And this issue of an uncorroborated observation by a police officer that he observed speeding is one that this court, I think, should tackle. And obviously, I have my perspective on how I think you should rule. With regard to the chemist issue, if there was a rule that said I could appeal this case directly to the U.S. Supreme Court, I argue to you that the Trump nominees, the Trump appointees, Gorsuch and company, would side with us. They're the ones who turned Burlingame into Smith v. Arizona, which turned into Thomas and Gleason here at the state level. They're from the Scalia wing. They believe in the right to confrontation.
I see that the green light is on. Can I go to one issue and that is the discovery issue? Even if I view the conduct in this case as incredibly concerning by the state and symbolic of what seems to be an endemic, frankly, across this state, what does it matter here? The witness we're talking about didn't testify.
Right. Yeah, no, that's right. And that's why the trial judge ruled against the sanctions motion.
Well, but I mean, he ruled against the sanctions motion, but at that point, I think people still thought he might testify. He didn't even testify.
No, that's right.
So, I mean, whether that was a sufficient sanction or not isn't even really raised at this point.
If this was a one-time
I said, even accepting what you've said, but all we can do is deal with this case. And how can there possibly be any prejudice if, in fact, the witness never even testified?
Well, I think Attorney Smith made the argument in his motion, if all that happens is, you know, a hard slap on the wrist by the court, including this court, it's just going to continue. I mean, it really is. I talked about my 160, I've done over 10,000 criminal cases, and with the digital evidence that's produced and all the evidence, and maybe it's not always the DA's fault. Maybe it's just a lot of evidence.
But my point is that how, in this case, can we possibly be positioned to do something about it when the witness didn't even testify, he wasn't even presented? What are we reviewing? We've got a trial.
Okay, well, and that's the way you'll approach it. I mean, you're the Chief Justice of the Maine Supreme Court. If you think it's okay.
Well, do you have an argument that you were prejudiced in this particular case?
Well, it took 2 years for the case to go to trial, for one thing. But what if the case had gone to trial and this very serious Giglio
Correct. And so now you're talking about hypotheticals. Is there specific prejudice you can point to that Mr. Rhoades was exposed to?
Not in the end, because you're right, the witness did not testify. But I still don't necessarily think that precludes a strong sanction here. This was an egregious discovery violation.
Can I go back to your first issue, the uncorroborated testimony of the officer? Assume that radar guns came into general use in the 1950s. How do you suppose they caught speeders before then?
Well, they boy,
relying on your personal knowledge.
Gosh, I don't know, but look, I don't think what we're saying, we're not asking this court to create any new law here, by the way, with regard to, like the Fourth Circuit, I think, did. I think the Fourth Circuit is sort of a minority view on uncorroborated.
Well, the Fourth Circuit really hemmed and hawed. It was really on the facts in that case, where it was only 5 miles and over. That particular officer seemed to think that there were 4 feet in a yard, or maybe there were 12 feet in a yard, or maybe we don't know what the heck we're doing.
Very fair point, and but I still think you've got to have something other than an officer saying, I looked up and I saw him speeding. It doesn't say how long he saw him speeding. Why was he parked at an angle that his radar couldn't pick up what was happening in the road?
But the standard is reasonable articulable suspicion. This isn't preponderance. It's not even probable cause, unlike for some reason in the Fourth Circuit case. It's reasonable articulable suspicion.
In the end, this is like a a movie reel where you're looking at one. We operate in a 3 or 4. We're in a multi-dimensional world here. He's looking at one moment in time. That's what he testified to in the 5-minute suppression hearing.
Doesn't it just go to the weight? And we have an officer here who's trained at the Criminal Justice Academy and showed that he could estimate with some accuracy, and he continues to test himself. And he says, that car is going really fast. That's going well over the speed limit. But you're saying, well, if we didn't have a good look at it, but doesn't it go to the weight?
Well, but this is where I'm concerned about what I've seen in the 40 years, that we're now doing suppression hearings where the officer says, 14 years ago, I took one stop,
But he got it right.
and that makes me qualified. I mean, come on now.
And he's been doing it for 14 years ever since on a regular basis.
I know, and
Well, when the speed is really excessive, I mean, even a layperson could say, you're in a 25 and someone goes zipping by you. An experienced driver could probably say that person's going way too fast, right? So it's a matter of degree, isn't it?
yeah, but see, I'm a defense lawyer, and I look at the testimony of law enforcement officers with skepticism. I've seen a lot of Giglio situations.
Yes, but the judge doesn't have to look at it with skepticism, does the judge?
I'm sorry, Your Honor?
The judge doesn't have to look at it with skepticism.
No, but I just think it needs, these are serious matters here, and why couldn't he just look down at his speedometer? Why was his radar not angled properly?
All good questions for cross-examination.
Maybe, but
Can we look at your issue regarding that you characterize as a surrogate chemist coming in?
well, I'm not so sure that Attorney Smith argued that at the time. I think he was arguing more of a gatekeeper argument.
Yeah, we have a preservation problem here for your confrontation argument, don't we? There was only argument about reliability. So this is an obvious error review? Do you agree?
Yes. That's true. I would agree with that, Your Honor. But, you know, and I think, of course, Smith hadn't come down at that time. I was just...
It had, actually.
Had it? I'm sorry, Your
Yeah,
Honor.
about a month before. I checked the dates.
I was just looking at the Smith definition of testimonial evidence, and I don't know how this doesn't fall under the definition.
Because what we are looking at in like a blood test is you're reviewing another person's actual analysis.
Right.
What you are looking for in a breath test is the machine spits something out. So all you're doing is checking the reliability of the machine, and then there is a person who you can have testify, but that person who is testifying is not testifying based on anybody else's analysis. They are not a conduit for anyone else's that you need to confront.
My Smith and Thomas and Gleason argument is that we're talking about the testing of the instrument within the 6 months.
All we're looking at there is reliability.
Well, the calibration of it, and you know, this is the separate chemist comes in, puts in a sample.
Well, we don't know if it was a separate chemist.
I'm sorry?
We don't know if it was a separate chemist.
Well, that's what Ms. Pease testified.
When you spit out a result from a machine, that's not testimony.
Right. I
So
totally agree.
all you're looking at is this machine reliable? You don't have confrontation rights about that. You're looking at reliability.
I think Justice Gorsuch and Comey Barrett and Kavanaugh would disagree with you.
Counsel, is your argument, I want to make sure I understand it, that the machine can't be reliable unless it was tested in a certain way, and we don't have direct testimony from the person who did that assessment? Is that the argument?
That's not just me saying that. That's Ms. Pease saying that. I cited her testimony in my brief.
But is that the basis for the confrontation claim, that we can't assess reliability without hearing from the person who assessed the machine?
You know, just like Smith v. Arizona, I think this is almost like a first-time question, even at the U.S. Supreme Court level.
But is that your argument? Well, can we just...
Well, you know, before Smith v. Arizona, you had this crazy Burlingame decision where, you know, Scalia was joining with Ginsburg, and the liberals were joining with Alito, and Clarence Thomas was off on his own, and you had a 4-4 and 1, and then in my Thomas case, Justice Stewart said, well, I know that we now have 3 Trump appointees. They're going to side with the state. And surprise, surprise, they sided with the defense because they're more, again, confrontation, Scalia wing, more libertarian than, this is not your abortion and voting rights issues that the Supreme Court's so controversial about. They defend defendants' rights.
Okay. Thank you, counsel. Attorney Smith.
Good morning, Chief Justice Stanfield and honorable members of the law court. May it please the court, I am Christopher Smith, Assistant District Attorney in Penobscot County, representing the state. The defense raises, I think, 3 basic points, and I certainly have all respect for those points of view, and well stated. I'll say just briefly with regard to each one of those. The suppression hearing, it was a proper use of discretion by the judge at the trial level, at the motion hearing level. The officer testified that his estimate was the defendant was going 55 and a 35. And that level of excess speed really would be obvious to anyone, even a minimally experienced driver, just by observation. I think a lay person would probably testify that the person went flying past me, that type of language. The case that the appellant cited to did actually make reference to a series of cases that they referenced with the degree of speed being much more than 5 miles per hour. And I think the basic conclusion of that case was that it makes a big difference if the speed is in significant excess or slight excess. And in that case it was 5 miles per hour. And there were just a number of issues with that particular witness's testimony beyond that. But that court was looking for some other indicia of reliability and indicated that significant excess in itself can be extremely obvious and by itself be that indicia of reliability. Officers do this every day, especially experienced officers have done this for years. And if their perception is that someone's going 55 and a 35, it's a pretty obvious reason to stop a driver. They'd be remiss if they did not do so. The officer could have simply stopped the driver for imprudent speed under Section 2074. So it is not a situation where the estimate has to be precise. The defendant wasn't charged with a particular speed, just with the obvious excess speed is a pretty significant reason to stop the driver. With regard to the qualified witness issue and the issue of that person as it relates to discovery, I have to own that particular issue. Mistakes are made, and that doesn't make it okay. The witness wasn't disclosed until after that should have happened. The request for the qualified witness was overlooked, and it was addressed certainly well in time for trial. And
Well, I see that the green light is on, and I appreciate owning the fact that you're owning that. It is, Mr. Hwanek is not wrong, and it seems to be a problem that is occurring more and more frequently, in general, I mean, with discovery obligations across the state. But can I turn to the admission of the test in this case? In your brief, you only argue that it was not an abuse of discretion under 2431 subsections H and I to have admitted, and didn't even mention confrontation clause argument. Do you concede that it's a violation of the confrontation clause?
Not at all, Your Honor.
Then what are we supposed to make of the fact that you didn't even respond to the argument?
Well, in hindsight, it would have been better, I think, to have responded to that, certainly. But I think that the series of decisions that have been issued by both the Supreme Court and this court is referenced even by defense counsel or appellate counsel. This is it's a self-contained breathing apparatus. It's self-diagnosing. You can't get a result from that unless it's functioning properly. And so the witness, who was, I would suggest, the lab witness as opposed to a simple officer testifying, or simply an officer testifying, that's kind of like the Cadillac versus the Yugo. And the transcript is replete with information about how that works, how it's tested, how it's maintained.
But here, Pease from Heddle did not know, she could not assert, at least, that she was the one who had tested it. She didn't have any personal knowledge of the testing. Why isn't that a problem?
Well, I think that we have a statutory scheme here that the legislature has created to deal with the admissibility of these test results.
This is a confrontation argument based on the Constitution, not the statute.
It is, but this is not a situation where another chemist has tested a particular substance. This is not the cases referenced are drug cases, lab testing. This is simply maintenance records. Are you suggesting
it's only applicable in those cases?
I'm sorry?
Are you suggesting the confrontation clause is only applicable in those cases? In drug cases, or?
No, but not applicable here in the sense that these are more like business records. The witness testified. She maintains these machines. She's the one that does this. She goes from Fort Kent to Kittery to do this twice a year.
So she's really sort of a quality control person. She's the head of this testing operation that takes place here. And as you know, if you hit a couple of bases as to how it was tested and the quality of the samples, then you get a streamlined trip into admissibility. But that didn't happen here. You had basically brought in a person who's called quality control, who says, yeah, we test these things and we use samples that are certified and all the rest of it. Ordinarily, that we'd have to bring in experts to testify if you're going to use subsection K. So in every case, the state's going to prosecute across the state. If we bless this, I'm sure the state's attorneys will say, all you got to do is bring in Pease. She'll testify. We test them regularly, and we use all the proper stuff. Thank you very much. It's reliable. Is there a problem with that? Just having someone without who can't say, I did the testing, but they're saying, well, I might have, but someone else might have done it, but they do a good job too.
And I think she testified that it was highly likely that she did that. She does it normally, and the other chemist was referenced as a potential fill-in if she couldn't
No,
for
she
some
didn't say
reason.
highly likely. She said that she does most of the intoxilizers.
Yes. She goes on, and there's someone that does that if she doesn't. But,
So 51%.
I mean, I certainly, the court has taken any view of that. I took her testimony essentially to indicate that she does it, and she's not meant to be the only one, but it's primarily her.
Does it matter? I mean, I guess that's, I think, that's, I think what Mr. Hwanek is really focusing some of his argument on, is that we don't know that she's the one, so she's essentially testifying as to the results obtained by someone else. Does it matter?
I honestly don't think it does, Your Honor. This is more of a record-keeping issue than anything else. There's a reason why that there are seals and there are initials put on these, because it's unreasonable to suggest, I think, that a particular chemist is going to have an independent memory after going through hundreds of these machines multiple times a year. And I remember a particular day and time when I looked at this particular machine.
But she also she testifies that records are maintained by the Health and Environmental Testing Lab. All she had to do was to look at the records, maybe produce the records as an exhibit at trial, or at least refresh her memory, before she comes up to the courthouse.
That would have been ideal. What she did testify to is that she was certain that that machine was functioning properly at that time, on that date.
But what was the basis for her certainty?
Well, her maintenance of the records, I think, was the key to that.
It was the seal, and she's not certain who affixed that seal. Is that correct?
She's not certain that she did do that, although, again, from her testimony, it seems highly likely that she did. She did allow for the fact that she may not have done it herself.
The concern is that if it were someone else who had done it, she may be able to testify about the typical practice, but in theory, at least, that someone else could have just come and slapped a sticker on without having done the necessary checks, and then you have Ms. Peace vouching that, yes, this machine has been assessed reliable without knowing whether that was actually the case. Isn't that at least possible under the testimony we have here?
Well, that would be certainly very, I guess I'd say, slipshod maintenance by a lab tech whose job it is to go and check the machines. And as she testified, it's a really kind of a simple process. It's very routine. And I think that's part of the reason why that the admissibility is allowed to proceed in the way that it does.
But if you were going to use the statutory subsections G and H, and it's really detailed, you have to show that the sample was certified by the manufacturer or otherwise tested, and how the process took place there. It's very detailed before the legislature has said this can go in, but this process here allows the state to kind of bypass all of that and say, we're bringing in the person who's the head of the department who says, either I or someone else checked it and we do a good job, and this is okay.
Well, and she did testify that they prepare the formula, and that the machine or the instrument really is essentially as close as you're going to get to foolproof. I think that's why it's treated in the routine fashion that it is, because even the site coordinator, she testified, their job is to make sure there's enough mouthpieces and put paper in the printer, those sorts of things. It's very routine, and all you have to do is take the cap off, put the solution in, close the cap. Any officer can do it. It doesn't have to be a site coordinator.
As to reliability, it's kind of answered in Beeler, isn't it? Where we had generalized testimony about how intoxilizers work and the police officer's testimony. And in paragraph 15, we said that was enough to prove reliability. So if we have a problem, and we also rejected a confrontation clause argument in Beeler. So then the question is, did anything happen after the decision in Beeler that would change the confrontation analysis? And is there anything in the more recent Supreme Court law that suggests that machine data is testimony?
I don't believe that there is. I'm not aware of it. I don't profess to know it for certain, of course, but I'm not aware of anything. Again, I think this fits in really the record keeping, and it's routine maintenance for an instrument that has to be functioning properly to give a result. And the witness was certain about the quality and the functioning of the instrument on that, at that time, and so that's why the court used its discretion properly to admit that,
So
that
on
particular
the,
result.
on the discovery violation front, because we keep seeing this happen, what do you think we can do to make it stop happening?
Well, I regret any oversights that occur. I certainly don't want to be in effect, the poster child for that. We try to be very careful. And it doesn't really matter at what level the request was overlooked. It falls on me as the prosecutor, no matter what level it got overlooked.
Is there a staff person within the district attorney's office whose job it is to touch base with the police agency and say, okay, on State versus Jones, do I have everything that you have in your possession? Or do you just wait till the trial rolls around and then somebody walks in and say, oh, by the way, we have this? It seems to me that's where things are falling apart. There should be a person, perhaps it's the assigned attorney, who is going to touch base with the police authority early on in the process, within 7 days after the plea, to say, have you given me everything you've got?
I think that would be ideal, certainly. And again, there's no excuse for missing something. It's easy to do with the volume of cases that come in and the volume of information that comes in. The amount of data can be pretty overwhelming. In this case, the request wasn't seen initially, and I do have to disagree with the suggestion that the trial would have occurred without this person, because we have to exchange witness lists, and the qualified witness wasn't listed on that, which makes it very clear that that oversight had occurred. And so the trial wouldn't have occurred without this person, because they weren't listed. And presumably when it actually got to a point of jury selection, the defense counsel, who was apparently very interested in having the site coordinator, they would have seen this person wasn't listed. So it would have been addressed at that point, which would have been very late in the process and could have been a significant consequence from that potentially.
But Mr. Hawanek's point is a valid one. We are seeing this routinely. In fact, I mean, discovery violations, I don't mean the specific violation that occurred here. But in fact, we had argument yesterday involving your office, involving another discovery violation that was, the results of a warrant, actually, that hadn't been supplied. How do we stop this?
I wish I had a great answer for that, Your Honor. I don't. I think just maximizing effort and trying to get fully staffed and deal with the volume of our cases. I mean, we've had cases certainly where there were significant consequences for discovery violations, oversights, including dismissal of cases.
And as I understand it, although Mr. Hawanek may not know this, you are now operating under a pilot program that actually has a scheduling order, and that information not supplied in a certain timely fashion will be presumptively excluded. Is that right?
That is correct.
Do you think that's going to help?
I think that it will. Deadlines always help attorneys, Your Honor.
Thank you, counsel.
Thank you, Your Honor.
Attorney Hawanek.
Much else, Your Honor, other than to address Justice Connors. I completely agree that spitting out data, numbers, is not testimonial evidence. I think what I would suggest the court do is go to Ms. Pease's testimony. I've cited it at the bottom of page 34 of my blue brief, and I think somewhere in the facts as well. And just read as she describes the process. And I would just suggest that that's more than just spitting out numbers, because I totally agree with you. But I think this is more than that. And I think when you take Ms. Pease's testimony and you compare it to the law in Smith v. Arizona, I think it's testimonial evidence. And if it's testimonial evidence, then I think you've got a Smith, Thomas,
Who's
Gleason.
other, but what you're doing when you're talking about the machine is you're talking about the reliability of the data coming out of the machine.
Yes.
It's a reliability issue.
You're talking about the Intoxilizer 8000.
Yes, the number.
And I'm talking about the guy who comes in 6 months earlier and says, all right, I've got a .10 sample here, and I got to go do this, and then I got to do that. That's testimonial. You got to do that properly. If you don't do it properly, then even Ms. Pease would agree that that affects the...
You lost me there about the the result that gets spit out by the machine is not testimonial. I mean, that's black letter law, isn't it?
That's correct.
So-
We're attacking, and this is why I think it is kind of a first impression. It's amazing that there was never a resolution of this between Burlingame
But is
back
there
in whatever
somebody,
the 80s
is there
until-
somebody who rendered an opinion or did testing that Pease or anybody else relied upon in making her opinion that it's reliable?
That's what I'm talking about here. So let's say it wasn't Ms. P. I think she said she did most of them, but she couldn't even remember if she did this one. Let's say it was Joe Smith. Joe Smith needs to come in and talk about
Well,
that.
she explained how intoxilizers work, and she explained about how you couldn't do it if you had a bad input. And
Agreed.
if we're only talking about reliability, she's not a conduit of anybody else's work. She's just explaining why you should deem the spew from the results from the machine as reliable.
I got it. I would just read Ms. Pease's testimony and look at Smith. And I
I think it's
you'll-
obvious.
Thank you.
Thank you. Thank you, counsel. As is our usual practice, we're going to be taking this matter under advisement and issuing a written decision in due course. Attorney Smith, somehow, in all the years that you've practiced, apparently you've never come here. So as is our custom, we would invite counsel to come back to chambers and take the greetings of the court.
All rise.
Please be seated. Good morning. Welcome. The next matter on our docket bears docket number Kennebec 25-235, State of Maine versus Jonathan Charron. The record reflects that counsel are present and prepared to proceed. We will be streaming our argument today live on the internet by video and audio. For that reason, I'll ask counsel please to stand in place, give us your name and the party you represent. First for the appellant.
Good morning, Your Honors. Attorney Dan Wentworth for Mr. Charron.
Good morning. And for the appellee.
Good morning, Darcy Mitchell for the appellee, the state of Maine.
Thank you. All right, we're ready to get underway. And counsel, I'd be happy to hear your argument on behalf of the appellant.
Thank you. May it please the court. So, Your Honors, I wanted to start by just sort of parroting some of the words of Mr. Charron that were also shared during his sentencing hearing, because before we get into the weeds of some of the more technical legal arguments, I think it's important just to lay out the humanity of Mr. Charron and some of the important work that he did while at the state prison that I think justify, that I think are just important to recall during this proceeding. And these were words that he wrote not knowing they would ever be presented to the judiciary, but were in an essay while he was taking courses through the University of Maine in Augusta. And he wrote that having lost all my possessions, vehicles, and life savings in the events that brought me here, I'm surprisingly optimistic about what the future might still hold, thanks to my faith. Faith has given me a new purpose and direction in my life to become a better person, a better man with each passing day. As Benjamin Franklin said, be at war with your vices, at peace with your neighbors, and let every new year find you a better man. And so I just think that...
words, but I see that the green light's on.
Sure.
So let's jump into the weeds as you described it. You have brought us an appeal here, and I just want to clarify where we're coming from on it, make sure we're all on the same page. It's my understanding that the sentence review panel has denied leave to appeal the sentence, and at this point we are here before the court only considering the legality, not the propriety of the sentence, and our review is de novo. Are we in agreement with those premises?
That's correct, Your Honor.
All right. So I'm sure my colleagues have plenty of questions to ask you. I'll just lead off with one. Your first argument was that the trial judge erred at Huey Step 1 by setting a basic term at 25 years. How is that illegal?
Yes, Your Honor. So I think that the trial court, in their ruling on the basic sentence, said that the biggest determining factor was the amount of drugs that were found on Mr. Charron. It was about 630 grams. Even though the court has some discretion there, that sort of setting of the basic sentence needs to be done through reliable evidence. And as I mentioned in my brief, there was no evidence presented to suggest that this was on such a high end of the amount that normally would be found on someone for trafficking to justify that. So there was no reliable evidence suggesting that.
So that might be error if we accept your argument. How is that illegal? What law has been broken there?
So, Your Honor, in State v. Ricker, 2001, Maine 76, paragraph 19, this court recognized that the use of unreliable evidence, or I would suggest in this case the use of no evidence, is in fact a due process violation and cognizable under direct review.
What do you mean there was no evidence? Was this a plea?
It was a plea.
And when the state entered during the Rule 11 proceeding, the basis for the plea, was there a description of the amount of drugs involved?
Sure. And I guess let me clarify that position, Your Honor, because you're correct. There is evidence about the amount of drugs, but the question really is that such an inordinate amount to justify setting the basic term at 25 years?
That's not a legal question. Does not go to whether it's a proper sentence for that amount as opposed to a legal.
I think there needs to be some evidence in the record to suggest that that is somehow that justifies setting the sentence on this extremely high end of the sentencing
What
spectrum.
kind of evidence are you thinking about?
Well, I think the state would be in a great position to present that kind of evidence because they...
Like what? I mean, specifically, what would this evidence consist of?
Yeah, so the Attorney General's office specifically prosecutes a myriad of drug cases throughout the state of Maine, and so they're in a great position to collect how many the information on, what are the average amount of drugs that are possessed during this type of stop, during any sort of aggravated drug trafficking charges. What were the amounts of drugs confiscated?
But the court here noted that the amount of drugs in question here was 100 times the amount that would justify a Class A offense.
Sure.
Why isn't that in and of itself
well, Your Honor,
a reasonable basis for the court to conclude that this is a serious event, for serious crime for purposes of Step 1 in Huey?
Sure, I think there's two answers to that, Your Honor, and one of them is sort of the qualitative versus quantitative analysis that I mentioned in my brief, where basing a sentence solely on the amount of drugs that were found, because we don't know how much actual fentanyl is in this mixture, makes about as much sense, as Justice Posner put it in a dissent, as basing a sentence on how much the defendant themselves weigh, because there's really no correlation between the seriousness of the conduct and the amount of this mixture. And I understand the legislature has said for the purposes of guilt or not guilty that the mixture, the entire weight, but
for counts one, the court relied on more information, more inputs than just the quantity of drugs. The court relied on the fact that there were firearms present, the amount of cash, victim impact. I mean, there were a lot of factors that went into the court's determination that 25 years, something more than the state recommended, would be the appropriate basic sentence.
Well, and I'm glad you mentioned victim impact, because I don't think I think that was another error in the court's analysis, because there was no named victim here. And so victim impact...
I mean, clearly this is a mercenary enterprise, and so the victims would be anybody who came into possession of this huge amount of poison.
I think that when setting the basic term of imprisonment and relating to victim impact, there needs to be a named victim. Understanding that obviously the legislature has an interest in controlling the sale of opiate narcotics. They certainly can do that, but for victim impact, there needs to be an actual named victim.
So let me ask you, if I could, just shift gears a bit to your next argument, which has to do with a double counting argument. And double counting is considered to be an illegal aspect of sentence, so that gets you into the door for an issue that's cognizable on direct appeal. I want to make sure, though, I understand what your argument is in terms of double counting. Within the four corners of the court's analysis, there was not double counting. I think what you're referring to as the factor that was double counted were the other convictions. There was another Kennebec County conviction and sentence imposed. Then there was a Somerset County case, conviction and sentence imposed. And so I think your argument, and I want you to clarify and correct me if I'm wrong, but I think your argument is that the court erred by considering the other Kennebec conviction and the Somerset conviction as aggravating factors in Step 2. And so in that sense, there was double counting because the defendant had already been convicted and sentenced on those charges, and it would be inappropriate and illegal for those convictions in the other two cases to be taken into account in setting the maximum period of incarceration. Do I have that argument correct?
That's correct.
So does that mean then, I mean, I think the logical implication of your argument is that it would be improper for a court anytime to consider other criminal convictions, other sentences, in other words, a defendant's criminal history. Is that where that leads you?
I don't think so, Your Honor, because this was post his conduct in the Kennebec case. So understanding that criminal history can lead to aggravating factors, I think the fact that it was post this conduct, and I also think there needs to be some link, some nexus between...
Doesn't post arrest or I mean, post-charge conduct that's illegal, doesn't that really bear directly on a person's remorse, person's acceptance of responsibility? I mean, because it would really mitigate those arguments, and a person's susceptibility to rehabilitation. I mean, if the person goes out and continues to commit crimes while being charged in the present case and subject to a bail order.
Well, I especially think in the context of Mr. Charron's case, where it's really understanding these are separate cases, but it's really one course of conduct while Mr. Charron was undergoing, was in the throes of severe substance use, and that he had then since addressed very significantly, as the court said in its own sentencing analysis, that Mr. Charron was the rare case, which I disagree that it was, that Mr. Charron was the rare case of an individual who had made such incredible progress.
Right, but those two convictions for crimes occurring while this case was pending are pretty significant. I mean, there was a 3-year sentence, I think, imposed in the Somerset case, a 1-year sentence imposed in the Kennebec case. I mean, those are major league crimes. So you think that a judge just has to put on blinders and disregard that pattern of criminal history?
I think in this case where he had been sentenced to those already, and sort of that criminality had been addressed, I do, yes.
Okay, can I ask you in your time remaining here, you faulted the court for not engaging the escape valve statute, section 1125, and you make the case as to why your client would be a good candidate, arguably, for that avoidance of a minimum mandatory sentence. But the judge disagreed and did not invoke that section. Isn't that a completely discretionary call left to the sound discretion of the court? I mean, that's sort of it's granted by grace and nothing less.
Sure, well, I think it was the emphasis on the notice to, as to the sentences that could be imposed that I think is really the issue there, and why it was illegal. Because the legislature made a clear, I think, signal with that statute that notice to sentences to be imposed is not necessarily the appropriate factor related to that sentencing statute.
If you look at the judge's reasoning, he's saying in so many words, not literally, but people dealing as a mercenary drug dealer and quantities of drugs that are deadly, and if you're in that category, you don't get that break on the escape valve from the minimum mandatory.
I think that also leads back to sort of the inappropriate nature of the first step analysis, and where there was no actual evidence that this amount of drugs is in this echelon of drug trafficker. Because
do you disagree that decision is committed to the sound discretion of the court?
I do disagree where it's not based on record evidence.
Well, I see your time is up. We'll hear from you again on rebuttal. And Attorney Mitchell would be happy to hear you on behalf of the appellee.
Thank you, Your Honor. May it please the court. In this case, there was no illegality and no error when the sentencing judge sentenced Jonathan Charron to 15 years with all but 8 years suspended and 4 years of probation. On March 18, 2021, a GPS tracker that had been installed on Charron's vehicle showed that the vehicle had left Maine and traveled south to Massachusetts, where it remained for approximately 5 minutes before traveling back north to Maine. Law enforcement stopped the vehicle in Maine and found that Charron was a passenger in the car. After a canine indicated on the vehicle, law enforcement searched the car and found 599 grams of fentanyl, along with over $8,000 in United States currency and 2 firearms. A subsequent search warrant at Charron's home in Oakland yielded more fentanyl, over $9,000 United States currency, and 2 rifles. The sentencing court concluded, based on these facts, that Charron was a high-level, armed, for-profit drug dealer. The court also observed that Charron was found with 100 times the amount of fentanyl required to give rise to the Class A offense to which he had pled guilty. The court found that there are not many worse ways to commit this offense. The court then, appropriately, refused to sentence Charron to less than the 4-year mandatory minimum sentence for this offense. One of the aggravating factors that the court considered was the fact that Charron had committed 2 new drug offenses while on bail in this case. Charron had been convicted of both of those offenses before the sentencing in this case took place. Charron concedes that post-arrest conduct can be used to aggravate a sentence when it constitutes evidence of a defendant's likelihood to reoffend. Nothing is more indicative of an individual's likelihood to reoffend than proof that he has committed the same offense or offenses again while awaiting sentence on the first case. Throughout his argument, Charron complains that the sentencing court should have given more or less weight to certain sentencing factors. That goes to the propriety and not the legality of the sentence. Because this is a direct appeal, this court is limited to reviewing only the legality of the sentence. The sentencing court here appropriately followed the law at each stage of its analysis. The sentence it imposed was legal and was within the parameters agreed to by the parties as part of the plea agreement. Charron's sentence should therefore be affirmed. I would be happy to take any questions.
When the court makes a conclusion that a particular quantity of drugs is a lot of drugs, that's one of these things where you draw the line between a little and a lot, does the court transgress into an area of making assumptions based upon facts that are not in evidence, using personal knowledge outside the record? Or is that something that's within the purview of the court's discretion to decide that this was a lot, and therefore when I look at the 4 corners of what happened here, the fact that there's a lot makes it a very serious offense?
I think it's absolutely within the purview of the judge's discretion. Right? Judges are sentencing drug cases on a regular basis, and so they're very familiar with the kind of weights that are being recovered. But beyond that, in this particular case, the sentencing judge didn't rely on that. He relied on the fact that the amount of drugs that were recovered from Mr. Charron were more than 100 times the amount necessary to give rise to the Class A offense under Maine law. That by itself clearly indicates to the sentencing court that this is a significant case, clearly warranting a high basic sentence.
Is it your position that all of the arguments are propriety arguments, not legality, so we should dismiss this as opposed to deny it?
Yes, Your Honor.
What about the double counting argument?
Insofar as the allegation is that the appellant is alleging that it's double counting to consider post-arrest conduct, the state disagrees with that position, Your Honor.
It's a legal argument, isn't it? It may be not a great legal argument, but it's a legal argument, isn't it?
It is a legal argument. That is one of the ways.
We need to look at it on a direct appeal.
Yes, Your Honor.
Ms. Mitchell, you pointed out that the sentence that was imposed here, 15 years, all but 8 suspended, probation for 4 years, is within the range that the parties had agreed to.
Yes,
cap
sir.
recommendation of 20, all but 12. That by itself, though, doesn't mean that the defense waives any legal challenges to the sentence that was actually imposed. I mean, the court could have reached the decision that it did about what the sentence should be, 15, all but 8, but still have engaged in some illegality to reach that result, right?
It could have, but it didn't.
No, I understand that, but at least in the abstract, theoretically,
yes,
there still could be an illegal sentence within the range that the parties presented to the court.
That is absolutely correct.
Appears there are no further questions unless you wish to address the court further. Well, thank you for your argument.
Thank you, Your Honors.
And Attorney Wentworth, you have reserved some time for rebuttal, I believe. Yes, 3 minutes.
Yes, Your Honor, and I'm happy to take any further questions the court may have as well. I think I would just emphasize in the first step the facts not in evidence. And this court, just a few years ago, I think emphasized this point in State v. Watson, where the same sentencing court did something similar, where it assumed things that were not in evidence, specifically the link between drug trafficking and, in his experience, murder. And so this sentence in court has done something similar in prior cases, and I think that that's relevant as well, that this was happening in a similar case, and that there just was no evidence to suggest that this amount of drugs leads to such a high basic sentence.
I'm struggling to understand your arguments. Watson involved a very different situation.
Understood.
Where the court was drawing on personal experience and making assumptions that were really not relevant, at least as the record was presented in that case. But here, there was a Rule 11 proceeding. At that Rule 11 proceeding, the state set forth its what the evidence would show if it went to trial, and included in that demonstration was the fact that there were 600 grams of fentanyl recovered. Why isn't that perfectly reliable evidence for the court, for the sentencing court, to use in fashioning a sentence?
Because the basic sentence is theoretically supposed to be placing the defendant's conduct on a continuum of the sort of, I guess, best ways to commit a crime and then the worst ways to commit a certain crime. And so to put that continuum at 25 years, there needs to be some comparison to other ways, at least when it really is, the court, I think, was very clear that it was mostly setting that basic sentence because of the amount of drugs. And so there needs to be some link to the amount of drugs being on the 90th percentile of the spectrum, which is where the court placed that basic sentence, and that just simply wasn't here in this case.
Well, just as Young pointed out, though, there were other factors that the court was looking at when it was making its setting the basic sentence in terms of the possession of the firearm, as well as I don't remember what the other factor was at this point. But in other words, it wasn't simply limited with respect to the amount of drugs. It was put in the context of other aspects of his behavior in the commission of the offense.
And I agree there were some other factors the court listed, but it's the sentencing court specified that it was the amount of drugs that was really driving its analysis. And so, yes, understanding there were a few other factors, that was the most significant factor, and given that, there just wasn't that evidence in the record.
Thank you.
Thank you.
All right, we appreciate the briefs and the arguments of counsel. We'll take the matter under advisement, issue a decision in due course. We'll take our noon recess at this time.